Welcome everybody to the Music Modernization Act, What It Means for You. I'm Jonathan Zalbin and I'm co-hosting this panel with Mara Kuj. We are lucky to have two of the people that helped push this act through Congress and helped craft it, Michelle Lewis and Shannon Sorensen. We're going to introduce them in just a second, but first we have a word from our sponsor, Maddie Madsen from Current Music.
Hi, everybody. Thank you so much for joining us in this really important discussion. My business partner, Christian Salyer, and I have a company called Current Music, and our goal has always been to champion independent artists, songwriters, composers, and indie publishers find ancillary ways of making money as musicians and publishers, and helping people understand how they can maximize their earning potential. So I want to thank the GMS for allowing us to sponsor this panel, and to thank Michelle and Shannon for educating all of us.
All right, thank you very much.
Just so you guys know, I put Current Music's website in the chat, so if you wanted to visit them and check them out and see more.
Thank you, Hunter. Awesome. So to start off, our first panelist is Shannon Sorensen. She's Vice President of Business and Legal Affairs at the National Music Publishers Association in Washington, D.C. Shannon was part of the team that crafted the Music Modernization Act and was a head lobbyist who moved the legislation through Congress with unprecedented support and unanimous votes in both houses. That's quite a feat in this day and age. Prior to joining NMPA in 2017, Shannon was counsel in the U.S. House of Representatives for Congressman Chaffetz, Republican Utah, and handling House Judiciary Committee issues ranging from intellectual property, criminal justice, and immigration. Shannon is a graduate of Brigham Young University and earned her JD cum laude from J. Reuben Clark Law School in 2015. All right, Mara.
And we also have Michelle Lewis. Michelle is one of the co-founders of SONA, and which is the Songwriters of North America. Did I say? And it is also, she's also a creators' rights advocate, and plus she is a songwriter who has had #1 hits, had records released, toured, pretty much everything, nominated for Emmys, everything. So we are going to get this started with some questions like, what is the Music Modernization Act? Because I think a lot of people just don't know what it is. And also, what is the MCL? Because we hear a lot about that. So what are the two and how are they connected?
Oh, the acronyms. That is the fun part. I feel like we should do a game of name the acronyms, ASCAP. I'm also on the board of ASCAP, so that's another acronym. That's a PRO. The MMA is not for mixed martial arts. It's actually, in this case, it's the Music Modernization Act, and the MLC is the Mechanical Licensing Collective that the MMA basically created. So MMA is the law, the Music Modernization Act is the law, the MLC is the entity created by the law to basically collect, match, and administer this new royalty right.
You take us briefly through your involvement, both of you, and your roles in, and also tell us about when you started on the act to, it just went into effect last month. So we'd love to hear your trajectory.
Sure. So I started at NMPA in 2017 in June, and at that point, the bill had not been introduced, it didn't have a name, and the structure was, we had some ideas, but it wasn't totally sure what would go into the bill at that point. So when my involvement started, the bill was really just in its infancy. There was an effort by the music industry to kind of get some of these reforms before that happened, called the Songwriter Equity Act. So in 2017, when I joined, kind of a lot of those pieces were on the cutting room floor, trying to figure out what of the Songwriter Equity Act could continue. And starting conversations with digital services and with Congress to get the support that we needed and to get the right kind of coalition to have a bill that could go forward. So when I started, it was really in its infancy, and then there were maybe 9 months of conversations between Congressman Doug Collins, who is kind of the champion on the effort, and the digital services and NMPA and SONA and the Nashville Songwriters Association as well. And over time, we all came together and figured out what we could agree on and then introduced the bill. And then after that, I did a lot of meetings. I was NMPA's primary Republican lobbyist at the time. So I was going to the Hill every day, meeting with, I think, every office in the House and Senate to get their support for the bill, and reviewing drafts and amendments and, proofreading every version of the bill that existed and trying to articulate what the changes were to staffers. So basically, it was my life for like 2 or 3 years.
Wow. Michelle?
Yeah, no, I'm a songwriter, so I didn't know anything about, lobbying, legislation, legislative language, much less like copyright law. I had just been, slogging it out as a songwriter in my studio. And during one of those, I started working in, and it's appropriate that I'm here talking to the Guild of Music Supervisors, because around 10 years ago, I moved from writing for pop music. I was writing for hits, like swinging for the fences, writing, pop hits, to writing for animation and television. And I got on a show that ended up being like a #1 show in its genre, this show called Doc McStuffins. And it ended up being this big show. If you own a 4-year-old, you know the show. So because I was in that little bubble, I didn't realize what had been going on with streaming. And I poked out of the bubble during one hiatus between series to write a pop song. And that pop song ended up becoming the song that was kind of a #1 worldwide hit called Wings for the band Little Mix. And I'm like, well, that's cool. And it was like 2013. I think I was comparing it to, I'd had hits sort of in the 2000s. And if you compare the sort of apples to apples of what a hit will earn you in 2013, 2014 to what it would make in 2003, 2004, 10 years prior, it's kind of mind blowing, because streaming just completely causes those royalties to just plummet. Like there was just, like my head exploded when I saw my first statement. And I thought, I knew what a hit was worth 10 years prior, and then I'm seeing it now 10 years later. So that kind of activated me into looking under the hood of what's going on with streaming. Turns out a lot of it had to do with consent decrees, but also a lot of it had to do with our mechanical side and the lack of sales. Now, being like what used to be album sales are now kind of being somewhat compensated for with streaming. And the fact that mechanicals were just so undervalued. So part of fixing that was, the fix to that was embedded in this new legislation, the NMPA. So that was kind of my, I founded SONA. There was, legislation on the table to fix some of these problems. The NMPA, as we'll get into, you'll see it's more of a list of fixes to decades of problems that had sort of evolved between, basically music being analog to going digital over 2 decades. So getting it passed in 2018 was literally 2 decades after the Digital Millennium Copyright Act in 1998. And imagine the amount of problems that can pile up over, the invention of the iPod to streaming to YouTube and all these things. So it was a lot.
Can either of you or both of you give us maybe some broad strokes on what the 3 titles are and what some of those things were on that list of, modernization items that came up in the act?
Sure. You know the titles.
I got it. Yes. So the Music Modernization Act, we're often referring to Title I, which is the part that created the MLC and addressed changes to mechanical royalties. But originally it was 3 separate bills. So 1 was the Music Modernization Act, which became Title I. 2 was the Classics Act, which was fixing a loophole in copyright that prevented recording artists from being paid for any digital radio plays of their works that were released before 1972. After 72 had protection, not before 92. So that was the Classics Act. And then the 3rd was the AMP Act, which was really non-controversial, simple bill that enabled Sound Exchange to pay producers and engineers directly. Whereas before they had to pay the artists and the artists had to pay the engineers and producers. So then going back to number 1, the Music Modernization Act, this is the bulk of the bill. It's 150 something pages, and it has a lot of fixes that benefit songwriters and music publishers, the copyright owners of the musical composition. Those changes include a couple of things on the mechanical side, which is the copies, like a digital sale or vinyl record or a CD, and then some changes to the way that ASCAP and BMI are able to negotiate rates. So on the mechanical side, one of the huge things that this bill did was eliminated a system where licensees could get a free license if they couldn't find the right copyright owner. And that was a huge problem for us. They want to use a song, they don't know who the owner is. They send a notice to the Copyright Office that says, we want to use the song, and then they get to use it for free. And copyright owners weren't getting paid for that. So fix number 1, we eliminated that system. Now under the MMA, through the MLC, digital services will pay for 100% of what they use. So all the royalties exist in the pool, nothing's being cut out, no uses are free. And then the second big thing that the MMA did for the mechanical side was change the standard that the Copyright Royalty Board, which is the panel of judges in the Copyright Office that sets the rates for mechanicals, changes the standard that they use to set the rates. It used to be this complicated balancing test, and now under the MMA, the Copyright Royalty Board is required to set mechanical rates according to what a willing buyer and a willing seller would agree to in a free market. So we're still under this compulsory licensing system in the law where if someone wants to make a copy of your song, they're allowed to, but now they have to pay you what a willing seller or what a willing buyer would pay. So it's not a free market, but it's sort of approximating a free market. And then the MMA also made some fixes on the performance side that allowed ASCAP and BMI to be randomly assigned a judge to oversee their rate proceedings instead of these specific judges that had overseen them for a long time that tended to give rate decisions that were not so great for the copyright owners. Prospective licensees knew that the judges weren't so great for the PROs, and they would use that to their advantage in negotiations. So now, instead of going to those same judges with these predictable outcomes, you'll get instead, randomly assigned to a judge for those proceedings, which will help, hopefully, result in both better rate decisions and more fair, good faith negotiating. And then the last fix in the MMA was that the PROs are now able to introduce evidence about what the sound recording side is paid in their trials to determine what the musical composition side is paid. So it used to be like if ASCAP and Pandora were in court, ASCAP couldn't say, here's what Pandora is paying the labels for the performances. Now they can. So that's a long list of things. I'm happy to unpack it if people have specific questions.
And just to add that up until more recently, the master was sort of, by the streaming services, the master were sort of valued anywhere between 12 to 14 times the copyright. That's been balanced out a little bit more, but being able to use, the value of the master in as evidence is huge as evidence to be able to point to what they make. And sync is a great way to, it's another thing we can point to because it's equal. It's 50-50, right? In sync, you have to pay whatever you pay for the sound recording, you have to pay for the copyright. It's a skew, and it's much less equal when it comes to the streaming payouts.
That's totally right. And a lot of that's because we're under these really extreme laws and regulations that don't let you negotiate in a free market. The areas that are the free market is sync, and sound recordings are paid much more equally, or musical compositions are, paid much more equally to sound recordings. So we're trying baby steps to fix that disparity.
So we all saw some news stories this week that involved the number 454 million that has gone to the MLC. And I bet that our viewers would like to know more about that. So what's going on with that? Where did it come from? And where is it going?
It's actually 424 million, but it's still,
off.
we were still pretty, happily surprised by the number. It was kind of what we were hoping, because the good news is that, that money has been money that the digital services have been holding on their side until they could find the right rights holders to pay out to. Now it's coming over to our side meaning the publishers and the songwriters, to match and pay out. And so that's what the money is kind of like the punchline of the MMA, really. It's sort of what we were, really all fighting for, was to get this, get this money, this unmatched money over to our side so we can figure out where it goes and pay the right people.
So what's the next steps for that? So the money has started going. So now it's going to be, can you explain a little bit about how the MLC will decide, where that goes?
You want to do that, or should I do that?
Sure. Yeah. So a lot of digital services, before turning the unmatched money over to the MLC, were doing matching on their own, meaning trying to figure out who the sound recording or who the musical composition owner was. The MLC is taking that over now. And hopefully, the goal is, because everything is happening in one place, there will be one comprehensive database housed in the MLC with all of the information. And the MLC is making it sort of a transparent process. So copyright owners and songwriters can go in and say, here's what I wrote, here's what I own. Oh, looks like that's mine. And then they can claim. So it's kind of happening on multiple fronts. The MLC has a vendor that's helping doing the matching. They also have a team of actual humans doing the matching. And then there's this involvement kind of for the first time on the songwriter and publisher side, where they also get to, go in and make sure that everything's correct and claim their royalties. So we'll match. And then at the end of 3 years and possibly longer, anything that remains unmatched will get paid out back to the music industry, back to the songwriting community on like a market share basis.
So I have a question. I'm curious how this act could potentially affect music supervisors. We're at the Guilds of Music Supervisors Conference, and what are some things that could potentially benefit supervisors in the workflow, and what are maybe some things to, be aware of?
That's a really good question. I mean, look, anything that upholds or creates value around copyrights, I think helps everybody that's, participating in that, in the industry. So songwriters are making more money, publishers are making more money. I think music supervisors are going to make more money because the tide is rising. The other thing
is
the
databases too. The
database. Yeah.
So I know a lot of people have asked questions about that.
Yeah. So that's the other piece of it is the data. The data. Now we're sort of mandated. Well, on the one side, just to not conflate it, Songview is not part of the MMA.
Oh, sorry. You're right. I think the database. There were two databases that came out around the same time.
You're exactly right.
One was SongView, which was ASCAP and BMI, and the other was the MLC. But I do think there's been a lot of interest from the supervision community in the MLC database because there hasn't been a good database of all the song splits.
That
But
is so
impossible to
true.
get, you know.
And to be honest, the digital services were complaining about that too. You know, if they're going to license something, they want to know what they're licensing. And that's a valid complaint. I think for everybody is, you know, you want to know who owns what so that you can go to do the right thing. So you're absolutely right. The databases are going to be huge. There's the database created by the MLC, which is the mechanical ownership database. And then there's the database that is SongView, which is basically a combined database between ASCAP and BMI's catalogs, you know, their repertoire, sorry. So between those two, I think now there's going to be some great tools to clear, right? You're now going to know who
I
has
just
what.
can't believe the amount of databases was zero until like 3 months ago.
Yeah.
It was insane. Like everyone wanted to clear stuff, would be like, so where do I go look this up? And it's like, oh, you have to like
Good luck. Yeah,
call
good
up
luck.
your friends, you know, go buy a CD somewhere, maybe like, you know, look it up on Genius. So just the fact that we're moving into getting that information together and that people are getting a little less proprietary about it is really important.
Absolutely. And it only works better for songwriters, you know, to know this stuff. It's definitely in our interest. And I'm just seeing a question, like there's, you know, there are other databases. There's other pretty comprehensive like sync databases that have a bunch of metadata that I know music supervisors really need, you know, vibe and tempo and things like that. I mean, those are not the difference between those and what we're talking about is those are more like private entities. The great thing about the MLC, and I would also argue about ASCAP and BMI, is they're nonprofits. They're not, you know, they're not owned, so they're free. They're free to the users, pretty much to anyone who needs to access them, which is a new tool as well.
Michelle, if you feel at liberty to talk about this, how is that different than, let's say, GMR or CSAC, you know, which are more in the for-profit sector?
I mean, look, I think GMR and CSAC all have to, all the US PROs have to work in tandem. I think what we're finding is that sort of trolling strategy is not really a strategy, because if you hold up the money, you're basically not going to get, the money's gone. So people are, I think all of the, and the PROs haven't been doing that I think that's actually not a thing among the PROs. The established PROs, there are new PROs that are popping up that might do that a little bit, but of the 4 PROs, I think transparency is absolutely, you know, a goalpost that everybody is heading towards, because it doesn't really help. I don't think it really helps them to kind of keep that stuff behind the curtain.
Right. We're stronger together.
Yeah.
Yes.
Hey, I wanted to ask some questions. I think we have a lot of very nuts and bolts questions popping up, so we're going to get to that soon, unless, Jonathan, you had other questions. But
I've been keeping a track of the questions in the chat as we've been going.
I just want to know what it's like going to Congress to lobby for this stuff. And you got to just tell us what it was like.
Wait, see, can we both reach for our...
It was a lot of work. Michelle and I both have many copies of like the signature page of the bill to commemorate the many blisters from walking the Hill and all of the meetings that we had. So it may be a little different.
Who is the person you would speak to at a particular office?
It depends. So for the committee, all intellectual property is within the jurisdiction of the Judiciary Committee. Mm-hmm. So that's like, I think 30 people in the House and some like 22 or something in the Senate. So those are like our primary offices where we're in there all the time. You email their staffers. It's very often a congressman's legislative director or their chief of staff that you meet with. But they might have like a specific person that does intellectual property sometimes. It just depends. And then for the Judiciary Committee, we also did a lot of meetings with the congressmen themselves. Because when things are in their committee of jurisdiction, they tend to want to be more involved than like someone that's not on the Judiciary Committee that has nothing to do with copyright. They might delegate it to their staff to take those meetings.
And I would also add to that if you're a constituent in an area that has a lot of music, so like the LA based Congress people, and definitely Nashville and Atlanta and New York and Miami, whether they're on judiciary or not, would tend to meet in person with the music people because they were our own, we're their constituents.
We had one, Michelle, I think you were in this meeting. We had one congressman that wanted to sing with us. Yes. I don't remember who it was.
Well, no, we had Karen Bass who sang along because we brought, in our little troupe, we had Shelley Piken and Pam Shane, and Pam wrote Genie in a Bottle. And so we all we had this kind of like funky, like acoustic version of Genie in a Bottle sort of worked out where we all sang backgrounds, I'm a genie in a bottle, baby. And
they sang.
You didn't sing. So we had this little thing in harmony. And Karen Bass was so into it. She was like, oh, I want to sing with you. And she was just like kind of groove. We have video of like all of us kind of grooving on the back, like on the backgrounds of Genie in a Bottle. Amazing. It was really fun.
I mean, it helps to have a fun subject matter to get, not only congressmen, but the staffers as well. They get meetings all day long from people on all different interest areas, but we came in with guitars. And that I recommend to anyone trying to get something passed through Congress, bring in some songwriters and guitars.
100%. Because we're in the elevators. I don't know if you've ever been to Congress, but it kind of looks like
that's how we
no. It's the halls of, unfortunately we all saw them on television, on last month. But when you're there, the elevators look like Hogwarts elevators. They're these like tiny little elevators that are like next to each other in like rows. And so you're squished in with other people who are lobbying, like they're tiny and they're all like from like coal industry, healthcare worker industry, and you're trying to make conversation because you're literally in each other's faces. But the music people obviously give good meeting. I think we have a little bit of a leg up on some of the others.
A little bit on coal.
We have
better visuals.
Definitely better soundtrack.
So I have a brief question, and then maybe we can take a look at some of these Q&A questions. I'm curious if you can talk just for a minute about the CASE Act and how that's going to look moving forward. So, we had the MMA get passed, it's gone into effect. Now, looking forward over the next 2-3 years, what do we have in store?
Yeah, the CASE Act is an exciting change in copyright law. It was recently passed in the omnibus that passed at the very end of December, I'm pretty sure. It is a bill that creates a small claims court within the Copyright Office. So a lot of creators, with the internet age, see their works being infringed online all the time, and they can't really do that much about it. You can send a takedown notice and they might take it down, but it's going to come back up again. And it's kind of this endless problem of internet piracy. And it can be really hard to combat if you don't have the time and the resources to either be sending notices all the time or to hire an attorney and sue someone for copyright infringement. So what the CASE Act does is makes a small claims court specifically for copyright cases. If the amount in controversy is less than $15,000, you can take it to the Copyright Office and arbitrate your claim there. And they'll have staff attorneys available to help you. And it seems like a really big step forward after the last couple of decades of copyright owners just losing out to digital piracy. So that, I don't believe it's not up and running yet because the bill just passed, but that will just be a new way that creators can enforce their rights without breaking the bank.
Yeah, I think it was in like the six figures that you had to get into before, you know, it was like over $200,000 just to get into just to get a claim going, I think, in on copyright. So now it's much less.
Big change.
Yeah.
Very cool. So
song owners don't have to go, you don't have to go to the small claims court. For copyright infringement, the statutory damages amount is $150,000. Right. So you can claim $150,000 and take someone to regular court, but you have to get an attorney and it takes a lot of money to even get the money, you know. So if you're claiming less than $15,000 now, you can just go straight to the Copyright Office.
Very cool. So Mara, I've been monitoring the chat for some questions, but maybe we can start fielding some of the questions from the audience. And if anyone has any additional questions that they haven't already posted, feel free to put that in the chat now and we'll get through as many as we can with our remaining time. But the first question that I'm sort of going to redux some of the ones that we've been seeing, but maybe you can just talk briefly nuts and bolts about, MLC, Sound Exchange, Harry Fox, the different organizations rather, and how they're all kind of either working together or not working together, and why we have this explosion of organizations. I think that should cover a few of the questions that we've had in the chat.
And it's appropriate because it's actually something we have to do every time we walk into a new congressional office. You know, we're going to have a new Congress now, and so educating new Congress members, new senators on music issues is always starting from sort of that place of how creators get paid. And it's pretty Byzantine. It's pretty nuts. You're absolutely right. There's all these societies, all these entities that basically are responsible for different royalty streams. I feel like Shannon probably has it down to a science. I feel like I'm going to write a song about it, and that will be the way I do it. I'm basically trying to write Copyright 101 in a song. It's Copyright the Musical that's coming your way. I just have to that's a challenge.
Is it in 3
No,
acts?
you know it so well, and you live it. I don't. I'm an attorney. You actually have, the actual experience of it, but I'm happy to jump in. So Sound Exchange administers a statutory license for the public performance of sound recordings over digital radio. That sounds really complicated, but Sound Exchange. So basically, if you've recorded a song and it's played on Spotify, Sound Exchange will pay you for that. The payment goes through Sound Exchange. The MLC is for musical compositions, so not even the same work, and it's for the mechanical side. It does not cover performance royalties. Those stay with the PROs. So when you have a digital interactive stream, if you are both the copyright owner, you wrote the song and you recorded it, you'll get paid from Sound Exchange, you'll get paid from the MLC, and you'll get paid from your PRO for all the different rights that are implicated.
Exactly. And Harry Fox, can you fit where Harry Fox is in with her?
Yes. So the Harry Fox Agency, or HFA, has long been an administrator of mechanical rights. They are now the vendor to the MLC. So HFA is working with the Mechanical Licensing Collective to do all of the matching that the MLC has to do. HFA has done that for a long time. Digital services could hire HFA, or publishers could hire HFA to go out and make sure that their licenses are being administered correctly. Now HFA works with the MLC using this database that they had created over the decades, probably longer than decades that the company has been around, to help the MLC identify and build its own database of, matching sound recordings to musical compositions.
So
Right.
there was sort of a follow-up question to this. Some people in the chat were wondering, should you register with the MLC or a PRO? And the answer is
The answer is is both.
both.
If you're particular, okay, so if you're a songwriter, you want, and if you're a songwriter, you want to register with, you'll have, obviously you're in a PRO. The PRO has nothing to do with the MLC because the PRO, the P is performance, the M is mechanical. So you need to be in your PRO. You can, and you're actually going to utilize your PRO for the MLC because that's where you find some codes that you're going to need to know about. So familiarize yourself as a songwriter with your portal, with your ASCAP or VMI or CSAC or GMR portal, so that you can become aware of some of the codes that are going to be relevant for MLC membership. So to join the MLC, you actually have to be self-published or an administrator of some kind of right. So I'm trying to be very clear with songwriters. We're telling them all to go register with the MLC, but they're registering with the MLC as publishers, not as songwriters. You can only really register with the MLC as someone who administers rights. So just to be very clear, when you go to register, bring over your publisher IPI, which you'll find on your, you create an entity on your, I'm B the dog music because my dog B. So you bring over your publisher IPI over to register, and you can join. You can join as a songwriter, but really you won't have access to register or administer anything unless you have your publisher IPI with you, because your publisher and your administrator are going to be claiming for you.
Great, thank you.
Does that make sense?
Yes, that makes sense to me. If anyone needs further clarification on that, it is a little bit complicated.
Self-administered, administrated, or self-published songwriters can absolutely and should join the MLC as publishers. It's confusing calling us songwriters.
Don't.
Right. If you have a publisher, don't.
They'll do it for you. But if you don't have a publisher, then you should be registering.
Exactly.
There was a question earlier on generally about royalty rates. The specific question was, is it still 91 cents for the mechanical license? That was the question, but I would like to broaden that question and sort of paraphrase. Michelle, earlier on, you talked about that, 9.1 cents. Thank you, Andy.
I was going to say, I wish it was 91.
I wish it was 91. I'm like, who gets 91 cents?
I thought
Sorry,
that
go
sounded
ahead.
nice to me. But you said the difference between 2013 and 2003 was a remarkable difference. I'm curious if you can talk briefly or generally about rates, where they were, and then where maybe they're headed now with this new act.
Right, you're talking about the CRB rate, I think. You're talking about the copyright, basically the
I believe so. I believe
Yeah.
that's what he was talking about. Yeah.
Where the royalty money went. I'm happy to start, Michelle, unless you want to
go for it.
So, as we talked about a little earlier, the Copyright Royalty Board sets the rates for mechanical licensing. That's a relatively new thing, I think, in the last, I want to say it was 2003. I don't know for sure when their first proceeding was. Before that, the rate for mechanicals was set in the law. And it was set, I think, at 4 cents in 1909. I used to know this off the top of my head when I was lobbying, but I'm not now. And then it was increased, I'm pretty sure in the 70s, to 9 cents. And it's stayed there ever since. It's 9.1 cents, and it still is 9.1 cents today for a copy of a song. That means if it was sold on a CD and you had a song on that CD, you got 9 cents for that sale. That's still the case, but the way that the digital services pay royalties is not 9 cents exactly. Like if you download a song on iTunes, that 9 cents is still implicated. If I buy one of Michelle's songs or a song that Michelle wrote on iTunes, she's getting 9 cents, period. But with streaming, it's a little different because obviously it's not like a purchase model. So they calculated royalties differently. And it still implicates the mechanical right, but it's based on a percentage of revenue has to go to the publishers. And it's subtracted from what the labels are able to earn. And there's a cap on how much a service is ever going to have to pay for music. And it's really complicated. And I couldn't even explain the math to you without like copious notes and diagrams. But that's where the money went, is when the consumption model changed from I'm going to go buy a CD to I'm going to listen to an album on Spotify. Rather than making 9 cents when I go buy that copy, you're now making a percentage of Spotify's revenue, which is significantly lower. So what we're trying to do with the MMA and with our Copyright Royalty Board proceedings is try and make that rate fairer, because it's really damaged the income stream for a lot of songwriters. And Michelle can speak to that, but that's sort of the mechanics behind it, is this switch to streaming and a different payment model.
Right. You totally explained it better than I could, Shannon. It's the former model that was based on sales was sort of like per unit, right? It was like it was easily, you bought a thing, you paid for it, a piece of that went to the writer or went to the publisher. Now, when we're streaming, it's more of a hybrid of a performance, because you're hearing it in sort of in the air, and is it a sale? It's like a rental or a lease. It's sort of a hybrid of the two things, like so there is a mechanical within that stream. That is what the MMA actually enshrines, that there is a piece of a sale within every time you stream something, like that you choose to stream it, that you kind of are like, you're kind of buying it for that minute, right? For that 2 minutes that you're listening to it. So there is a mechanical associated with that moment of listening to it, but it is like 0.0038 or 2, depending on which service. When you divide it by stream, it is fractional.
Very cool. There was another question earlier on that I thought was an interesting question about Songtrust. If either of you know anything about that, and should people sign up for that or just go direct to these other? Do either of you know?
Songtrust is great. What I will say is it's worth it to just try registering for the MLC and getting your payments direct, because it's free. There's no charge associated with it. I mean, Songtrust, a service, if you don't want to deal with it, a service is great because you're paying for it.
And that's one of the big things that the MMA did, is the digital services pay for the operating costs of the MLC. So there's no commissions taken out. You're getting the royalties that are paid to the MLC that are yours. There's no commission. So I am not crazy familiar with Songtrust. I can't speak to that. Maybe that's a good option for people, but it is a big victory that you don't have to have any commissions taken out of your royalties through the MLC. And it should be, they have a lot of help to help you get signed up and a lot of instructions. And, you should, I echo what Michelle said, try and sign up by yourself, because it's designed for you to be able to use it.
Yeah.
And one more question, because I've seen this pop up a few times. I think some of the people in the audience would like some clarification between Harry Fox Agency and the MLC, and why you should be with both of them.
There's still some remaining rights that Harry Fox administers that the MLC doesn't. Lyric rights. I forgot some of the others, but there's still some things that the MLC is it has one job. It's this one right. It's the digital streaming. It's an interactive digital streaming royalty. So there's other rights that say, like music royalty, like MRI and HFA still cover Sound exchange is obviously a whole other thing. That's on the performance on the sound recording side. So there are a lot of entities to join. The MLC is it's one right. It's totally worth it to join.
So if I can summarize, basically join every organization that you possibly can so that you can maximize the monetization available to you.
Exactly.
Is that, yeah.
Mm-hmm.
Great. So I think we're just about out of time. I don't know if Hunter is still there, so we can direct everyone to the, someone's asking summarize. I'm not sure, Spring, I understand the question, but
it's basically both. Yeah, do both.
Okay.
Like join Sound Exchange, join MLC, join Harry Fox, join MRI.
Yes.
Make sure you're like in tight with your PROs, and kind of keep an eye on all these different streams.
Great. So thank you, Shannon. Thank you, Michelle and Myra. Great having this exchange back and forth. Hunter, are you on to direct everyone to the next panel by any chance? Maybe. Oh, it looks like what's the score? Zoom is all the way up, scrolling up. But really, thank you so much. This is extremely informative. I learned a lot. I'm sure everyone else did. And we really appreciate your time and your expertise. And more importantly, thank you for making this happen for all of us out there, because it makes our lives easier. It means that our business is better, and it means we can all grow together. So really, thank you.
I hope so. I'm still so psyched. It's just so funny that we both have just still laughing that we both have our laws within
Never
arm's
out of
reach of our
arm's
desk.
reach.
Yeah, exactly. So funny.
Thank you for having us.
Thank you.
If anyone has other questions that weren't answered, I'm happy to email.
Yeah.
I don't know.
Same.
Should I just put my email in the chat or?
Yeah, put your email in the chat. Perfect.
Or join SONA. Join SONA.
Join
If you're a
SONA.
songwriter, join SONA. Writers, join SONA.
Michelle, can you give me the
If I
URL
want
for
emails
that?
forever.
Yeah, it's wearesona.com.
Okay, great. Awesome. Well, thank you.
Thank you. Like people were lobbying.
I'm now just catching up on the chat. Are we supposed to log out now?
I'm not sure. I'm going to stick around for a minute. Just to...
I'm reading all of the questions now.
Yeah,
There's
I
a
think we
lot of
covered.
questions. There's a lot of questions.
Oh yeah, and there's Doc McStuffins fans. That's so awesome. That's really sweet.
Oh, that's awesome. I don't have kids, but my friends that have kids, they all watch that show.
I'm telling you.
And they all love it.
It was so life-changing to like be involved in a show that had so much.
Shannon, can you send your email again? People are re-asking.
Yes. Don't use my email to like sign me up for junk mail, but please feel free to email me if you have questions. I'm happy to try and answer.
Everyone's like, we won't.
Oh my God. And right, Maureen reminded me, Julie and the Phantoms. I just did Julie and the Phantoms. That was last year. That's this past year.
Cool.
Thank you, Maureen. That was you. That was all you. I love my music supervisor friends.
It's such a cool job.
It's such a cool job.
I'm a little jealous.
Oh, it's so the best. And when we were doing, because it's one thing when you're doing animation, you're not actually in the room with each other, which is why it was pandemic proof. But when you're doing live action, like with Julie and the Phantoms, you actually get to go on set and like, it's really fun.
So cool.
Yeah.
Well, if I could write music, but I am just a lawyer.
You're the yin and the yang, right? I'm not sure which is which, but I know one is creative and the other makes the creative happen.
I don't know either. But yeah, I'm happy to be involved. I love music. I'm glad I get to work on these things, even being extremely left-brained or right-brained.
It was so much fun lobbying with you, Shannon, that we had so much fun. It was like, because it was just, it's one of those things that it's such a unique experience. I totally like recommend if you ever have a chance to do it. Like, it's one of those things that's so American in its essence. So it was like, you're exhausted. You're just like, who's next? You find
fell
yourself
asleep at my desk after they're called fly-ins whenever you have people come in and you go walk the halls. I fell asleep at my desk at like 4 p.m. on a Friday because we've been lobbying all week. And DC is a lot of walking always. The hill is huge. So I always tell people, don't wear heels, don't wear any shoes that you can't wear for 7 miles in one day.
Oh, my Apple Watch
So
is
much
just
walking.
like 24,000, steps on my watch. Yeah.
When I was a brand new staffer on the Hill, my second day, my feet were bleeding and I had to go emergency Band-Aid. And then after that, never wear heels again.
Oh my God. What about Amelia?
Huh?
Amelia.
She's good at walking in heels.
She never doesn't wear heels. She
must have comfortable heels then. But it's a crazy thing that you don't think of. You're like, I'm going to go to the Hill. I'm going to dress professionally. I'm going to wear my heels. And you don't know that it's like, it is so much walking. We probably walked 5+ miles every day that we did the fly-in because you try to make all your meetings in the same building at one time and then you move to the next one. But sometimes you're like sprinting back and forth. And I had a broken ankle when I started this job.
Oh my God.
We're actually just chatting. You guys, it sounds like we should wrap up.
I just got a message that
wrap up at the next
time
panel
for us to end the
All right.
We thought we were all gone.
We would be at happy hour doing this,
I
but
didn't mean to interrupt, so no, you guys are good. Thank you, guys.
I'm hosting
Thank you
Name That
so
Tune.
much.
So if you guys want to come and at 6:30, we're doing Name That Tune. So if you want to hang out.
All
That
right.
sounds like fun.
Okay. So
Okay,
I need to
thank
log
you
off
again.
now.
Yeah, we're going to leave. the
Okay.
chat.
Guys, thank you so much. It was
Thank you
really
again.
great.
Good to meet you,
Thank
Laura, Jonathan.
Thanks
Bye.
again.
Thanks
Thank
to all
you
the
so much.
panelists.
Bye,
Bye.
guys.